Welcome to the Beverly Hills Bar Association's International Family Law Series. I'm Alphonse Provinziano, a family law practitioner based in Beverly Hills, California, and a fellow of the International Academy of Family Lawyers. And in this episode, I will be joined by Makiko Mizuuchi of CastGlobal Group to discuss family law and practice across the United States and Japan. And you might say, well, what is the crossover between the US and Japan? And many cases that we've seen in the last several years are Japanese expatriates living here in California. And when you think about it, Japan, if you look on a map, it's one of our neighbors. There's an ocean that uh, cuts between us, but there's so many connections between Japan and the United States. And one of the hardest things I found in my practice is how do you find somebody in a foreign jurisdiction when you're really in need of that crossover case? So when you have a situation that comes up, you want to know somebody immediately that you can reach out to who's going to be able to advise you on Japanese law. And that's Makiko Mizuuchi. She's a Japanese qualified attorney and also is dual qualified as a California licensed attorney here. And she practices on international family law and cross-border inheritance matters. And in addition to meeting with her in person and hosting this episode at the Barcelona conference I was at, she's visited us here in Los Angeles and we've collaborated with her extensively. And she is a very knowledgeable person on the areas of family law in Japan and has more than 15 years of experience handling complex multi-jurisdictional cases, advising clients on international divorce, child custody, Hague Convention proceedings as it applies in Japan, cross-border adoption, and global estate planning. And she works closely with family law practitioners and has extensive relationships with crossover issues in Europe, North America, and the Asia Pacific region. And it's going to be a great discussion that we've had with her, and so many interesting contrasts between the two jurisdictions and how they deal with family law matters and crossover matters.
Thank you so much for having me today, and it's always so nice to see you.
It's always a pleasure.
It's always a pleasure to see you, and especially so nice to see you in Barcelona.
I know. It's sort of the magic of the IAFL that we get to bring so many people from different countries and continents together. And it's nice for the membership of the Beverly Hills Bar to kind of benefit from hearing what you have to say. The wonderful thing for us is having such a great resource in you, and a lot of people may not know this, is that you're a California licensed attorney, but also based in Tokyo. And for us in the U.S., we have so many citizens of Japan working in the tech industry, working in professions, business owners, property owners. And so it's a very timely thing to be able to talk with you about what are the cross-border issues in family law. And one of the biggest things that we always like to talk about first on our podcast is how you have the spouses. Let's say there's people that are both U.S. citizens and Japanese citizens. How do we determine jurisdiction for a divorce in Japan? If the parties need to file for divorce, how does that start out with?
Yeah, but it depends on the case. But now we have a law which actually stipulates the jurisdictional issues. So, but basically, the residence of the opponent is the place where the court has a jurisdiction. So, for example, if the wife living in Japan would like to divorce with the husband in California, in principle, the court in California has a jurisdiction, but also the Japanese court, consider the fairness of the both parties. So if the court in Japan considers that Japan has a jurisdiction for the divorce case, considering the fairness between the parties, the Japanese court decides that the Japan has a jurisdiction over the divorce case. But it really depends on the case. So they consider various factors.
And when you have that, let's say, for example, you have the husband that is in California and the wife goes back to Japan and takes the children. And once she wants to file in Japan, but the husband's in California. Where would jurisdiction fall in that type of a situation?
Well, so it really depends on the case.
Of course.
But probably for the divorce, the California court may hold the jurisdiction if the husband lives in California. But for the custody issues, probably the Japanese court may hold the jurisdiction over the children's matters. That is because the children live in Japan now. So definitely, and the Japanese court also considers maybe the factors. I mean, especially the reason why she needed to come back to Japan to live with the children. So it really depends on the case. So I cannot tell for 100%. But the Japanese court may decide that the Japanese court may hold the jurisdiction over the divorce case and the custody case.
That's so interesting. So you could have a situation where there's a split, where the divorce goes forward in California, for example, but custody is decided in Japan. And you've seen that in your practice?
Yeah, but for the custody matters, probably the California court does not hold the jurisdiction. Am I correct? Because the children do not.
It depends.
When the husband started the case, probably the children were not living in California. So
yeah, that's the interesting thing. We see, for example, the marriage is dissolving, and let's say the mother says, "Well, I have some ill family members, and it's the last chance that they're going to get to see these family members before they pass away." And so she leaves, and let's say she stays in Japan for 3 months, right? And husband, under California law, can file to have the children returned because California still has jurisdiction. He didn't consent to the children permanently leaving the California. So he wants to bring the children back, and it's within 6 months. So California is still going to say it has jurisdiction. Mike, I'm kind of curious. In Japan, for jurisdiction, is there a certain period of time that they have to have for the children? And maybe tell us a little bit about that.
That's quite interesting. So, well, it's really hard to say how the Japanese court decides. In that case, but however, this is my impression. Japanese court tends to actually grant the jurisdiction for various cases. So, for example, if the mother has to start the proceedings in California, it may cost a lot, and she has to probably retain an attorney in California. That's a big, actually, a burden for her.
Yes.
And also, and the children live in Japan now. In that case, even though it might be temporarily, but the children live in Japan, and the court may consider the fact that the children now live in Japan or reside in Japan.
Right.
So the court may actually decide that the Japanese court may hold the jurisdiction over that case. But it really depends on the case. So
right. Yeah, it's always complicated as to how that turns down. And it sounds like there's not a clear time rule in Japan. It's more the fact is that the children are present in Japan that the Japanese court is going to look at. Is that right?
Yeah, and the fairness is very important. So the court needs to consider various kind of factors. Considering the financial situation, and the children may actually live in Japan for quite a long time period, or the reason why the mother needed to leave from California and so forth. So,
and what reasons would be acceptable in Japan for why mom would have to come back to for the Japanese court? What would they feel as an acceptable factor? Would it be family in Japan, or family support, or more financial means in Japan? What would they be looking at?
Well, for the divorce cases, apart from custody matters, probably the reason why she needed to leave from the U.S. to California, or and is it fair for her to start the proceedings in Japan? And so the court really considers fairness, and also we don't actually care much about the nationality, but it really depends on the case. But the court may consider the various factors whether or not to actually start the case in Japan.
That's so interesting, and. I'm just kind of curious, is it true in Japan, before you file for divorce, you have to go through a mandatory mediation?
Yes.
And tell us
call
about
it,
that process.
Yeah. We call it a conciliation instead of mediation. And the conciliation proceedings are part of the court proceedings. So we call it the court-based conciliation proceedings. But except for special circumstances, such as like one party is missing or another party lives abroad, in principle, the parties need to actually go through the conciliation proceedings before filing for the divorce suit.
Got it.
Yeah.
And then do a large number of cases settle in conciliation proceedings, or do a lot of them go forward and get decided in the court system if they don't agree?
Well, but at first, we have quite a rare system called like divorce by consent.
Right.
So many, especially like both parties are Japanese, they agree to divorce, and if they have children, they decide which one hold the parental authority over the children, and then they submit the divorce papers to the local government office, and they can divorce in Japan. But if one party or both parties are not Japanese, the situation may be different. But for the domestic cases, in a kind of regular case where like both parties are Japanese, I mean, if they cannot agree on a divorce, in that case, one of the parties filed for the petition to start the conciliation proceedings for the divorce cases. And if they cannot, reach an agreement in the conciliation proceedings, then one of the parties can file for the divorce suit. So that's
so
a kind of typical procedure.
Do approximately 90% of the cases get resolved in the conciliation proceedings?
I think most of the cases are resolved in the divorce by consent.
Right. Okay. Even before that.
Yeah, but probably you may be right. I don't remember the exact percentage, but probably probably 90% of the cases.
Wow.
In the are resolved in the settled in the conciliation proceedings. If they started the case in the conciliation proceedings, probably 10% of the cases go through the divorce suit.
Wow.
By my understanding,
Wow.
but the percentage may not be correct.
That's so different than the U.S. because so many cases get resolved by the court. About 80% of the people in California going through divorce are not represented, and only 20% are represented by attorneys. So the court system is having to bear that burden where they're having to resolve. The judge is sitting on the bench. He or she is having to resolve the dispute between the married couple. It's really kind of a nice system in a way that you have a consent system, a conciliation system before you get to divorce court. It has a lot less burden on the system and the judges to have to decide the cases. So that's really something to consider. And is that all? Is that paid for privately? Do people have to pay for an attorney to help them in the consent system, or is that done at the public expense, or who pays for that in Japan?
Well, in the conciliation proceedings, many people actually represent themselves without retaining the attorney to represent them.
Right.
And it really depends on the case. But of course, they can retain the attorney to represent themselves, but not all, but in some cases they self-represent. They represent themselves.
Yeah.
But when they file for the divorce suit, it's a real they in the court, they have to submit the kind of a legal documents. They have to make statements. They have to submit the evidences and so forth. So they tend to actually retain the attorney to represent them. So that's quite common. And but the situation is quite different, though. For the foreigners' cases, in order for the divorce to be recognized in the foreign countries, the Japanese lawyers who handle international family law cases recommend the foreigners to divorce in the court, at least in the conciliation proceedings.
Yeah, and why is that?
Yeah, because for example, in the U.S., only divorce is actually granted in the court proceedings. So, in order for the divorce to be actually recognized in their native country, even though they actually divorce in Japan, they may need to actually divorce in the court-based conciliation proceedings at least, or in the divorce suit. And the agreement in the divorce conciliation proceedings are actually regarded as has the same effect as the final and binding judgment.
And that makes so much sense because in the conciliation proceedings, you're going to get a court order that then can be recognized in another court. And is that how you advise international families that they should go forward so that they can have an enforceable judgment in another jurisdiction?
So firstly, they obtain probably the agreement in the court or the judgment in the court. And then it really depends on the jurisdiction. Probably the judgment in the court may not be recognized automatically in their native country. So in each jurisdiction, they may have different regulations or the rules. So we have to ask, probably the U.S. attorneys.
Right, of course.
About them. Probably in the U.S. Also, each state has a different rule.
It's the interesting thing about the U.S. because we have over 57 jurisdictions. And I think that's something that a lot of people don't appreciate. I imagine in Japan, if you're an attorney in Tokyo, are you able to practice all throughout Japan, or is it specific for each province?
Yeah, our license is a nationwide license. So once we actually are qualified in Japan, we can practice, in every region, everywhere in Japan, all over Japan.
And your focus is Tokyo. That's where you're from.
Yes.
I'm kind of curious. Something that really is critical for a lot of families facing an international divorce is how different countries treat child custody. For example, in California, there's this concept that there's a presumption of, it's not necessarily written this way, but the way the law is worded is that there should be frequent and continuous contact with both parents and their children. Is there any particular approach in Japan for child custody?
Well, now, at this moment, we have the system called sole parental authority system. But as of April 1st this year, 2026, a new system will start, and the parents can choose the joint parental authority. We call it parental authority, so joint parental authority system. So the situation may become different, but at this moment, currently, one parent holds the parental authority, and another parent holds a contact with the children. And the court really encourage the contact between the a non-custodial parent and the children. But in fact, and for example, if the mother holds the parental authority, and after they divorce, and the father has the contact with the children, in that case, if the mother is reluctant to have a contact with the father, in that case, and the father may file for the visitation or contact, conciliation proceedings to the family court. But still, they cannot reach an agreement. In that case, the court issues an order, but in that case, probably once a month visitation or contact for 2 years is still a kind of common standard.
Oh, interesting.
In the country.
And there's a little bit of at least from some cases I've had, and that sounds like it. So it sounds like as of April 1st, there's a change in the law in Japan that at that time now you can consent to joint parental control. Prior to that, was it more? Did it heavily favor, for example, did it favor the mothers in custody in Japan, or did it favor one parent over the other to have custody?
Oh, well, it doesn't mean the mother holds the parental authority or not, or the father may hold parental authority or not. But if they can reach an agreement by which parent will hold the parental authority after the divorce, or they may choose to hold the joint parental authority after the divorce. It really depends on each couple, each parent. And we really have to see what's going to happen after the revision of the law will become effective. So the law, actually, like the revision of the law passed already. We are just waiting for the a revision of the law to become effective. That will start April, I think, as of April 1st.
That's so interesting. And is there, let's say, for example, you have a U.S. custody order, and it's for joint parenting, and it says, maybe, for example, it'll say that the father is relocating with the children to Japan, and mother is going to have visits in the summertime, possibly take the children from Japan back to the U.S. Is that child custody judgment, is that enforceable in Japan?
Well, it's kind of really difficult to enforce. There's no automatic enforcement of the custody orders. So if the father holds, in this case, custody, joint custody, and what kind of situation, are you thinking about? The mother refused to...
Yeah, let's say father gets to move, has a U.S. court order to move to Japan. And the mother then comes to Japan and says, okay, it's summertime. I want to have the children under this U.S. court order. Will Japan enforce the U.S. court order and give her the children for the summertime?
So in this case, the mother still lives in California.
Right, yeah.
And the mother, if mother would like to change, for example, from joint custody to sole custody, she may file a petition to the Japanese court to change the custodians of the children while children reside in Japan. Yeah. Children need to reside in Japan in order to start the procedure.
So she'd have to go through the Japanese courts then. And I'm kind of curious, Makiko, I know Hague Convention, that's your area of expertise. Can you tell us a little bit about your background handling Hague Convention cases in Japan?
Yes, sometimes I represent the taking parents, but mostly I actually represent the left behind parents living abroad. That is because the left behind parents. We call them LBP. Hard to find lawyers to represent them, and but in principle, actually, of course, we have a Hague Convention Implementation Act, so we really follow the Hague Convention. And in principle, the children are returned. The court orders the return of the child to their country where they are habitual residents.
And is Japan a signatory to both Hague Conventions, or just to
just the 1980 Hague
just
Convention?
1980?
Yes,
okay.
Yes.
And and then it sounds like there's legislation in Japan to implement how you handle Hague Conventions. Tell us a little bit about, if we have a client in California, and let's say they want to contact you about they have an abduction and they need to have the child returned to them in California. What's the process in Japan to seek that?
Yeah, the first, he or she may need to contact the Ministry of Foreign Affairs. It is a central authority for the Hague Convention cases, and they provide assistance to you, and they send an actual letter to the taking parent, and they may actually support the ADR. But if the father or mother, LBP, would like to actually start the court case, through the assistance of the central authority, they may actually file for the petition for the return of the children to the U.S. And the Minister of Foreign Affairs actually has a list, and they actually introduced 3 Japanese lawyers who can handle Hague Convention cases. But the left behind parent can look for another lawyer to represent represent themselves. So it really depends. But anyway, so the LBP actually retains an attorney to represent them, and they start. He or she starts the case in the Tokyo or Osaka family court. The cases are concentrated on just 2 family courts.
That's interesting. And how long does it take to go through the Hague process in Japan?
Well, in principle, the court will try to actually proceed the case very, very promptly, following the Hague Convention. And probably in general, the Hague case, in the family court may actually end within a few months.
Oh, really?
Yeah, but it's very kind of common in Japan. The court will not actually issue an order very, very immediately, but in general, they refer the case to the conciliation proceedings. But in fact, most of the cases now, recently, were settled in the conciliation proceedings.
Really?
Yes.
Oh, wow.
Yeah,
so you have to go through conciliation process even with the Hague Convention?
During the court process.
Oh, wow.
The court referred the case to the conciliation proceedings.
What kind of settlements do you see in general? Do you see people agreeing to return the children or agreeing that they'll stay in Japan? What do you see frequently?
Well, not just... but it really depends on the case. Some cases, they reach an agreement to return the child to their country, but in some other cases, they reach an agreement not to return the child. But in that case, for example, the left behind parent has a contact with the children. For example, in summertime or wintertime, and it really depends on the case. But also, for example, if they reach an agreement to their native country, to the country where the children were habitual residents, in that case, they just make an agreement. They also make an agreement about other matters, such as, for example, if a taking parent will go back to their country with the children, and in that case, the parent may actually cover the living costs of the taking parent, or how they actually hold the contact with each other, and various kind of things. They may actually make an agreement of other matters.
Interesting.
Yeah.
As part of a condition of coming back from
So,
Japan.
but in that way, for that reason, it is much better to reach an agreement in the conciliation proceedings, so they can make lots of kind of agreements.
Right.
But when the court issues an order to return the child, they cannot. Under the Japanese law or legal practice, the court cannot actually issue an order of the undertakings. They just decide whether or not to return the child. So it's much more valuable to make an agreement in the conciliation proceeding for both parties.
Now, if it breaks down, let's say they don't have an agreement in conciliation, does it go to a judge then to make a decision in Japan as to if the child's going to be returned?
Yeah, yes.
Is that a trial? Are there witnesses called, or is it done more in written documents? How does that procedure work in Japan?
In general, they don't call witnesses, but the witnesses is just submit their actually documents.
Okay.
So, but the court will actually hold a hearing about both parents.
And what happens at the hearing usually? Do they ask questions of the parents?
I guess, yes.
Interesting. But most of it's all submitted in writing in advance. That's so fascinating. And let's say a parent really doesn't want to return the child from Japan, wants to keep them in Japan. Is there any real challenges to a parent trying to get the children returned? Are there successful defenses in Japan under the Hague Convention that you've seen that will keep the children in Japan, or is Japan, in your experience, usually returning the children to the home country?
Well, it really depends on the case. So,
Sure.
but And if they cannot reach an agreement, and in principle, the court, in principle, the court order the return of the child.
Right.
So the taking parent has to take the burden to prove that there are some grounds not to return the children. So if the taking parent is not successful, the court will order the return of the child. So, but the taking parent, of course, can appeal to the High Court, but the High Court will not actually grant the non-return of the child. In that case, the court judgment becomes final and binding. In that case, and still, if the taking parent does not return the child voluntarily, the left behind parent can resort to the enforcement procedure, and the enforcement officer goes to the residence.
Really?
Of the house and take the child.
Wow.
Right. As far as I understand, according to the Ministry of Affairs, I mean, the enforcement successful rate of the enforcement is about 80% now.
Wow.
Yeah. So
have you seen that where the enforcement officer has to go and take the child?
But in my case, I mean, fortunately, all the cases didn't go to the enforcement part. That is because actually, it's quite rare that the case goes to the enforcement procedure.
Right.
And especially recently, most of the cases are settled in the conciliation proceedings, and so most of the cases are actually resolved amicably.
Right.
Sort of,
right.
Yeah.
That is so nice because in the U.S., many of these cases go. You do have parents that return the children and agree to go, and in California, we have a system with the Department of Justice that then sends the cases out to the local prosecutor, and the prosecutor will try to get consent. They'll try to get the people to agree. But if it does go to court, there are certain defenses to the Hague Convention that can be very litigated, and the process can take, depending on the experts you talk to, it's supposed to be done in 6 weeks, but a lot of times can go on for a very long time because it can be very lengthy trials in federal court. They can even go on for years with appeal. So it's really such a contrasting system in Japan, where it sounds like, in your experience, that the emphasis is on let's work an agreement out. Let's either the children are going to stay or be returned, and we get the consent of the parties, which is really amazing. Something that in California, we have a 50-50 division of assets. And I'm kind of curious, how are assets looked at in general in Japan when people are trying to decide, look, do I want to file in Japan? Do I need to file in California? What should they look at in terms of asset division and how assets are divided in Japan?
But in principle, just like the community property system in California, we divide marital property 50-50. So I think the Japanese system is quite similar to the community property system in California.
So there's not that much difference then in that principle.
In principle, yes.
Is it in practice? I know since you've done an amazing feat in being a California licensed attorney and a Japanese attorney. In practice, is there differences in Japan? Is it sometimes less than a 50-50 division?
Yes. But in principle, we have a very similar system. So, inherited a property is not included in the marital property, or the gift is not included. So it's quite similar.
And is everything before marriage, is that considered separate property of the spouse?
Exactly.
And then after marriage.
Exactly. So
do they get into these complicated? In California, we have to do tracing, so we have to find. If it's separate property, but it goes into the same bank account, let's say the family buys a house with it. If you can't separate it out, you're in a situation where they'll consider that to be potentially community property with the 50-50 share. Is that similar in?
Yes. I mean, it's a commingling is a is an issue too.
Yeah, that's so fascinating. And in terms of, we have cases, for example, let's say the parties are residing in California, but they have assets in Japan. Let's say they have, they left Japan, they were coming to the States to pursue a future where they had better income, but they have family properties in Japan. They have some houses. How are those properties valued in Japan under the Japanese system? For in California example, you'll have an appraiser. An appraiser is going to go out, take a look at the property, and they'll say, "I'm looking at this estimate of value on comparables of other sales in the neighborhood. And I estimate that this property's value is $1 million." Do you have that similar system in Japan, or is there a different system to value property?
Well, in many cases, the parties do not want to spend lots of money
Right.
for the valuation, so they go to the real estate agents. I mean, they actually evaluate the value of the property in a very reasonable price. So they often go to the real estate agent. So, for example, the wife goes to A real estate agent, and the husband goes to the B real estate agent, real estate agent B,
Yes.
and they compare the price,
Right.
the amount. And if they can reach an agreement, that's fine.
Yeah.
But if they cannot reach an agreement, they go to ask the real evaluator, the qualified evaluator to evaluate the amount or the price of the property. But it is very costly. So it's try to avoid that.
Right. Yeah. So that's a more sophisticated system. And the interesting thing in California is to get an appraisal of property, it could be as little as $500 US. Is it a lot more?
$500?
Yes. Yeah.
$500?
Yeah, to value a
appraisal?
property. Yeah. Is it?
Oh, much more expensive. Probably if they go to the qualified evaluator, probably they may charge $2,000 or $2,000 or more than that.
Wow. And what is that evaluator called? Is that an appraiser, or do they have a specific title in Japan?
Yes, I just don't remember the exact title.
Yeah.
But they are actually qualified. It's a nationwide, actually,
interesting.
A qualification. So.
Oh, wow. Wow. That's so fascinating. And it's not done by the real estate agents then in Japan.
So it's more reasonable to ask a real estate agent to evaluate the price.
Let's say, you get your court order in California. And the court order in California says we're going to award the flat in Tokyo to one of the spouses. Is that judgment from California enforceable in Japan?
Actually, no. It's kind of really complicated. But even though the California court order that the wife holds a property in Japan, but that order cannot be recognized, easily. The property is located in Japan. But for the monetary orders, they may be recognized, and as long as they satisfy the requirements under the civil procedure code, Article 118. We have a specific article.
Right.
Yeah, but
so if it's real property, it's very hard. But if it's money, a money judgment, it's easier to enforce it against a Japanese bank account.
They have to file for the enforcement. File for the enforcement litigation case to the court, but as for the real estate or property, they also have to fight for the division of the matrimonial property in Japan in order to divide the property in Japan.
And have you seen people work with, let's say they have assets in Japan, but they're divorcing from the U.S., do they work with the Japanese attorney to make sure that the orders are then enforceable, or have you seen it more people come to Japan with foreign orders, and then you have to determine if it's enforceable or not?
Well, so the U.S. In that case, U.S. lawyer and the Japanese lawyer need to collaborate with each other.
Yeah.
So if the real estate is located in Japan, and the husband would like to transfer the property from the husband to the wife, in that case, they have to go to the court. Probably in that case, probably wife, maybe, fight for the division of matrimonial property to the court in Japan, and the family court in Japan.
Wow.
Yes.
Wow.
So it's the collaboration is very important if a property is located in Japan.
And I'm kind of curious. In California, we have a system of spousal support and child support that's based off of the incomes of the parties. When the parties get divorced in Japan, how do they look at? Do they have those concepts of spousal support and child support, and how is that structured?
Yeah, in Japan, the court has a calculation table for the children and the maintenance during the separation period. So we follow the calculation table for the typical cases. But if the case is not typical, we have to calculate by hand.
Oh, interesting.
Yeah, we have to calculate. Yeah.
Is it a generous system of spousal support payments? Does the spouse, let's say, like there's a mother that stays at home and takes care of the children, and the father is the person that goes out and he makes a great living, and then they get divorced? Does the wife get an equivalent amount to support her standard of living for when she was married, or is she looking at much less?
Yeah, I mean, unlike the system in California, we don't have the alimony system. So the wife does not receive the kind of alimony after. The spouses do not receive alimony after the divorce. So the living standard tend to become lower. Only we have the system child support. So
and child support, is it a system where you can get a reasonable amount of money, or is it also the mother in this example, would she be looking at getting a lot less than what she was having a part of when she was married?
Well, I mean, if the father has a higher income than the mother's, and after the divorce, mother received the child support, probably the amount of child support may not hold the same living standard, maintain the same living standard. So probably the mother needs to work, but for the special expenses such as private school education or the medical expenses, probably they can make an agreement about the special expenses. So other than the monthly child support.
Will the Japanese courts order certain expenses to be paid? Like, for example, will it require the husband to pay for housing for the mother and the children? Would it require him to pay for a car or childcare services, or is it all just a lump sum of money, and then the mother has to figure out what to do with it?
Yeah. I mean, just the total amount.
They just get the set amount, and then they have to budget the money.
Yes.
That's so interesting. And of course, we contrast jurisdictions like in England, where the parties can get very large lifestyle orders. They can get houses and all sorts of things. It's very similar to California in the sense that it's just a fixed amount per month. And now, can you get lifetime alimony in Japan, or does it go away very quickly?
No, we don't have alimony, so
no alimony at all.
No alimony, but in a very special cases such as another spouse or the wife is very elderly and there's no property to divide. In that case, the court may order the sort of kind of alimony. I mean the money to support her after the divorce, but that's quite a rare case. So
wow, so really, parents only looking at child support, and their standard of living is going to go down. And then they sort of have to live off of whatever the asset division is, without any kind of potential future considerations for their support needs. Is that right?
I mean the matrimonial property is divided by 50-50. That's a very standard practice. So,
wow,
that's true. So we really have to consider if, for example, California and Japan, maybe the jurisdiction both California and Japan become jurisdictions for the case. So probably as an attorney, probably you have to probably when you actually advise to your client, probably you may need to consider which jurisdiction is a better place for her or he or for him to start the procedure.
I mean, it is one of those things that we always factor in when you're looking at two different forms and you have a way to file. A jurisdiction like California is really enticing for the spouse that doesn't make that much money, because California has these expansive spousal support laws where the law is that at least at the beginning or the onset, you're supposed to look at just the income of the spouses on a temporary support order. And then more long-term, it's the marital standard of living. So how has this family lived over a long period of time? What's that going to look like? So that's really fascinating, a contrast. And so if you're the party, it sounds like if you're the party that makes all the money and you have all the income, it's a little bit more advantageous to you to file in Japan if you can, than not.
Well, I mean, like in California, if you are married more than 10 years, the alimony is going to you may receive the alimony
for life.
The presumption of the alimony is going to kind of is set under the law.
Yes.
So that's quite different.
And there's no concept of that in Japan.
So we don't have alimony in general. So. But when you are still married, but you live separately, in that case, I mean, the spouse which has lower income can receive the maintenance. We have that system, but they need to receive. They can receive maintenance as long as they are still married.
Interesting.
Yeah.
Wow. And is there, out of curiosity, what do you deal with? International matters, Hague Convention matters on a regular basis. Where do you see the future of international family law in Japan? What do you see on the horizon that we should know about?
Well, I mean, as of April 1st, 2026 this year, the new system of the joint parental authority or joint custody starts. So we have to see what's going to happen, how the court will handle custody cases in the future. So probably within 10 years, probably we may see the different kind of legal practice in Japan.
Right.
And we have to see what's going to happen. And then, as I just said, if both California and Japan hold the jurisdiction for the divorce case or the custody case, in that case, we really have to actually consider which actually country or which jurisdiction we start the proceeding. So we have to think about that. So it's very important to collaborate with each other. I mean, California lawyers and Japanese lawyers. And also, as long as the couple has property in Japan, I mean, the Japanese proceedings, the proceedings in Japan is necessary. So I think the collaboration between the California lawyers and Japanese lawyers are very, very important.
And I just wanted to thank you, Makiko Mizuuchi, for coming with us here today and talking to all of the listeners at the Beverly Hills Bar Association. I know that if there's a Japanese family law issue that comes up, we know who to call now. And thank you so much for your contributions today.
Thank you so much for having me. And it's a great honor to be interviewed by a very experienced family lawyer. I really respect our Provinziano. Thank you.